I'm going to call your case. This is Esurance Property and Casualty versus the Michigan Assigned Claims Plan and the Michigan Automobile Insurance Placement Facility. This is a mini oral argument on the application. You each have 15 minutes. Mr. Broadus, that means you can try and reserve some of that for rebuttal. We hope that you can try and manage that on your own. We'll see how it goes, and you may proceed when you are ready.
Thank you, Your Honor. Drew Broadus for the defendant appellant Esurance. And I'm just looking for a definitive explanation of why my client doesn't have a cause of action. And this is as you're aware, first party no fault subrogation action. I believe we should have a suit and that the C8 ruling should be reversed. There's really just two simple reasons. Equitable subrogation exists in the no fault context, has for a long time. Even though it's not in the statute, that was the trial court's reasoning for dismissing this case. Auto owners versus Amico is on point, at least in regards to the workers' comp act. I don't think there's any argument that that was wrongly decided or should be revisited. So the big proposition is, yes, we have equitable subrogation as a remedy. And an insurer that pays on the basis of a mistake is not a volunteer, which was the Court of Appeals reasoning. So what we have here, we had a policy that was rescinded, was deemed void ab initio in another action. And the Court of Appeals found an issue with that. It was a new argument in the Court of Appeals. It wasn't the basis for the motion or the trial court's holding. And there's some surface appeal to it, and I understand why they might have struggled with this. But at the end of the day, it's no different than any other insurer that pays due to a mistake of the facts of the claim or their legal obligations. And I think what happened here is rescission has been a hot topic for the last 3 years. It's been the source of some confusion, particularly before Bozzi was addressed by this court, which these decisions were made at a time when Court of Appeals was still wrestling with the issue. So I think what happened is the fact that there was rescission in play here, and kind of sprinkle in the fact that you had assigned claims also in the picture, which was at least part of their initial motion. Everyone kind of assumed that some new rule must apply because of these unusual facts. But at the end of the day, it's a very simple situation. We had ensured we were wrong about our duties. We paid under penalty of interest and attorney fees under the statute. It doesn't have to be a smart move. The case law simply says it has to be reasonable payment to protect yourself and your legal rights. And that's what we did. And at this point, I don't know if there's free fire at this in a moment. If there is, I'll waive it. I'd rather answer questions than repeat my briefs.
Yeah, thank you very much. Let me see who has questions. I'll start with Justice Clement.
No questions, thank you.
Justice Kavanaugh.
No questions for me.
Justice Welch.
No questions.
Justice Zara.
No questions, thank you.
Justice Viviano. Oh, I skipped Justice Bernstein. Oh, no, it's not your turn yet, Justice Bernstein. Justice Viviano.
I'll bite just for one or two quick questions, counsel. On this issue of whether your client was a volunteer when it made payment, you're relying on the Dye case, is that right?
No, I don't think Dye versus Esurance. Yeah, I didn't.
Dye versus Detroit Mutual Auto Insurance Company, the 1953 case.
That's one, yeah. That's one that lays the foundation. There's a number of cases that support this proposition. It's a general proposition, so I cited that. I don't have particular emphasis on that, other than it's from this court, and it goes back a long ways and it's been cited a lot of times.
What's the particular reason why your client was a volunteer? What are you relying on?
Why we were not a volunteer?
I mean, not a volunteer, yeah.
Right. We are a no-fault carrier. We were presented with a claim. We at least ostensibly had a policy that was relevant to the order of priority. Whether it was later rescinded or not doesn't change the fact that at the time we were certainly regarded as being a carrier that was potentially in line for this claim. And so we're presented with the claim, and we have obligations under the statute that can make that exposure get a lot bigger if we don't do the right thing fairly quickly. So we acted, and there's case law from other states that I've mentioned in my brief that suggested insurer is presumptively not a volunteer when it pays under similar circumstances, when there's at least an arguable duty. So that's, I think, the key in a nutshell, the arguable duty.
Yeah, I guess that's what I'm trying to get at. Are you relying on a Michigan case that's adopted sort of this? There's a lot of different definitions of who is a volunteer, I guess, and who's not. And the Dye case lists a whole bunch of different ones.
Yeah, I think.
So are you asking us to adopt a principle from another state's case law, or are you asking us to apply a principle that's in our case law?
No, I think our situation fits neatly in Michigan law. I don't think this court needs to go outside of the state. I cited cases from outside simply because I thought they helped illustrate the point. But I think any definition of volunteer that you use, we don't fit as an insurance company that's presented with a claim, and we have a no-fault policy that is at least arguably relevant to that person's injury. Specifically in the context of our statute, there's some serious penalties if we don't act. So I don't think this requires a new rule of law on what is a volunteer. I think the deviation from our common law was the Court of Appeals finding, and I think the Court of Appeals got there simply because of this. Not to say a red herring, but they placed undue emphasis on the fact that rescission was out there and was in play, and it's a new issue. So they thought, well, geez, if you're void ab initio, you're not even in the line. And that has some logic to it, I understand, because that is our position. The policy's treated like it never existed. I don't disagree with that. But you can still make a mistake. I mean, I think it's the dictionary definition of mistake controls here. You think you had a policy when you didn't, and you pay, and there's someone else that should have paid, you can at least make the case under CA. They may have other defenses that haven't been explored that aren't part of this record. It's not the same as sticking them with the tab. Just want to be clear on that. But
that's all I have.
thank you.
Justice Bernstein.
No questions, thank you.
Okay, you may continue, counsel, or reserve some time for rebuttal. Up to you.
I think I'll reserve.
Okay. Ms. McAllister, you may proceed.
Thank you, Your Honor. May it please the court, Lori McAllister, appearing as counsel for the Michigan Auto Insurance Placement Facility, who is also the administrator of the Michigan Assigned Claims Plan, which I will shortcut as MACP because the prior sentence is way too long to say every time that I want to address my client. I think that fundamentally the problem with counsel's argument is the very last point he made. Hey, we're not sticking anybody with the tab. That's exactly what they're trying to do in this case, in which the Court of Appeals said, you do not have a basis to do that in this type of situation. The Court of Appeals was very careful when it looked at this legal fiction of equitable subrogation. And it said, even though as a legal fiction, we apply that legal fiction to say the policy is void as to the policyholder, that doesn't mean that it's void in all other contexts. And I think implicitly this court recognized that when it decided Bozzi, because you said when you have a third-party claimant that's involved, you can't just say we rescind and it's void ab initio. Instead, you've got to look at the various factors to determine whether it's equitable to have that situation apply. They are seeking to go one step further and make the argument that counsel really didn't address, which goes to the issue pointed out by the court, which is even if you say that it's void ab initio as to the policyholder, why would that holding bind or be applicable to the Michigan Assigned Claims Plan? Michigan Assigned Claims Plan did not have any involvement in the alleged fraud. MACP did not advise his client to pay when there was no payment due in priority. They have been deprived, my client has been deprived of the opportunity to go in, argue the Bozzi factors. They've been deprived of the opportunity to adjust the claim, to handle it through their normal practices. And instead we're being told, well, because their policyholder committed fraud, that somehow that means that there's an equitable claim 2 steps down. We're not only going to apply it as to the third party without doing BASI analysis in this case because it was before BASI, but we're also going to apply it to the MACP, who had no involvement and has no equitable, there are no equities that would say you should apply it in this situation. And again, I think BASI stands for the proposition that just because you void a policy ab initio as to a policyholder doesn't mean that it's void ab initio as to all other purposes, particularly here when we had an innocent third party, but then 1 step removed to the MACP. The Court of Appeals, we submit, got the issue correct in terms of looking at the situation and whether or not they could be characterized as a so-called volunteer, which I know is an issue that Justice Viviano followed up with a bit. I don't think that the answers that were given to that question are appropriate under the circumstances. The Court of Appeals was correct when they said, basically, you can't have it both ways. If you're going to take the position that there is no policy and you're going to get the benefit of saying that that policy is void ab initio, then you are stuck with that as a finding. And in that situation, you are paying without a legal obligation to do so or a contractual obligation to do so. And that's what the Auto Owners versus Amico case that he talked about found, was you can have equitable subrogation in situations where there's a contractual or statutory obligation. This is not one of those situations by their own choosing, because they have decided to void the policy on the basis of fraud. So we therefore do not think that it's appropriate application of equitable subrogation.
Council, let me interrupt you and see what questions my colleagues have. Okay.
Certainly, Your Honor. Thank you.
Thank you. Justice Clement.
No questions.
Thank you.
Justice Kavanaugh.
I just have a question. Isn't it, to me, the issue of fraud and voiding the policy ab initio really is irrelevant? I recognize that we sort of teed that up in our MOA order, but this isn't a case where the insurer had an obligation to reimburse until the policy was voided, right? Their contention in their answer, and I think, was always that they didn't have an obligation to reimburse them because they were not, they didn't in actuality insure the injured party, any member of his household, the owner of the vehicle, or the operator of the vehicle. I mean, it just so happens that the fraud here goes to the ownership issue, but if they're not in order of priority, I don't see why the fraud is really relevant. I could see in a case where they did insure the owner. There's no question of that, but there was some fraud in the application, say, as to perhaps where the car was garaged or some other issue like that. But there's no question that this person owned the vehicle. And when that, then maybe that tees up this sort of harder question. But here, it's not. They never insured the owner of the vehicle.
Thank you for that question, Justice Kavanaugh, because it allows us to sort of clarify that point. You are right that we emphasized the point we did on fraud, because that was a question that was teed up for the parties. But with respect to this argument that, hey, we were never in the priority chain, that is an argument that is based on mistake. And I would submit to you that that has not been recognized yet by the Supreme Court as a basis on which you can do equitable subrogation against the assigned claims plan. So for a couple of reasons. First of all, the only Supreme Court case which referenced it is the DAII case, which was decided in the 50s. And it was not a holding in that case, but instead just an excerpt from the AmLaw jurisprudence that was cited by the court when it was reaching its decision. But furthermore, even if it's a mistake, to me, that's an even better reason why they shouldn't be able to go against the MACP. The MACP is not a backstop for insurers who make mistakes when they're handling claims. It's unfortunate that they made a mistake, but why should we create a cause of action for equitable subrogation in those situations and make all the drivers of Michigan pay for the fact that they made a mistake? It certainly, the MACP has taken over the claim and pays it on a going forward basis, but why should we reimburse them for the error of their ways? So
Figured out early on or right at the get-go that they didn't, that their insured didn't own the vehicle.
yes,
Wouldn't they have proceeded to file a claim with your client at that point?
yes, they would have. And if in fact they were not in the priority chain, then it would have been an eligible claim at that point. But they didn't do that in this situation. They instead made the decision that they were going to rescind on the basis of fraud. That's what they got their judgment against the insured for. And that's what they decided to plead in their complaint as the reason that they were going for this particular remedy. And that's why I think the Court of Appeals was correct when they basically said, look, you've made your bed, you've got to lie in it. If this is the theory that you're going to advance, if this is why you're going to rescind this policy, then you are stuck with that. And I think the Court of Appeals got it right in that situation, particularly when you're dealing with a claim against the MACP, which we found no reported case since 1973 where any insurer has been allowed to pursue a subrogation claim. This is a situation where you're balancing equities between the driving public who pays for the MACP versus the insurer who made a mistake. And in this situation, I don't think all of us should pay for the mistake that they made. I'm sorry they made the mistake, but it shouldn't be an MACP responsibility to pay for that mistake.
But had they not made the mistake, MACP would have been paying anyway, right?
We would have, Your Honor.
Okay.
No question about that. I think the issue is, do we, in this case, allow them to create a legal fiction to pursue us for liability? They could have solved this by having someone do, 10 minutes of research. The fact that they didn't shouldn't be an obligation then that we have to pay for and not have any opportunity to manage a claim that they've already spent nearly $600,000 on.
Okay, thank you.
Justice Welch,
No questions.
Justice Zara,
No questions. Thank you.
Justice Viviano,
No questions. Thank you, counsel.
Justice Bernstein,
No questions. Thank you, counsel.
you may proceed with the rest of your time if you'd like.
Like the last attorney who went a little short, I'm also aware and sensitive to the court's time and can tell from the questions I did receive that the court has done their homework. So we appreciate it. We ask that the court deny the application for leave to appeal.
Thank you very much, counsel. Mr. Bradis, you have some rebuttal time.
Thank you. I think we've come full circle. We had a motion in the trial court that basically said this suit doesn't work because we're the MACP, and we've come back around to that, which I don't think is a valid reason to support the C8 ruling or the Court of Appeals result. At the end of the day, we have to have a rule on subrogation that applies not just in this case, but to no fault in general. And there's no doubt that if an insurer made this mistake and the truly responsible carrier was simply just another carrier, not an assigned claims carrier, the cause of action would exist. So it's come back around to, well, we're special. We don't, and I think there's a lot of cases that say they're not. There's numerous cases where the MACP has been sued to compel an assignment, for an example. And so it's a non-starter in my view. And the Court of Appeals didn't adopt that either. So I have, and then I'll be short, but I have 4 fundamental problems with the way they've argued BASI, and particularly the innocent third party aspect. The first is that for the purposes of the C8 record, they've accepted the rescission. So it's not, they haven't preserved that as a part of the appeal. if it's something they want to deal with, if this case comes back, certainly they can bring what I would think would be a C10 motion if they wanted a balancing of the equities on that. But it's not a challenge to the pleadings, and it hasn't been presented as so we're not there. The other problem with that is when we step into the shoes of the innocent third party, that's us. We are the innocent third party in the subrogation suit because that's whose shoes we step into. So it's an odd result to say the equities don't favor us, so we don't get a cause of action. It's kind of what that boils down to. And the last point about that is when you look at the so-called Markman factors that were later adopted by the Court of Appeals in Pioneer. One of those factors that makes it equitable is if there's redress against the assigned claims facility. So for those reasons, I don't think the rescission defeats our case. And I'll leave it with that.
Are there additional questions for Mr. Broaddus from anybody? Well, thank you both. The case will be submitted.